That's the big key takeaway from this video is if you want your will to control it, it has to. Hi, Jeff Marsacci, the Plain English Attorney. Welcome to the video. Today we are going to talk about funding your will, which doesn't seem to be right. Usually it's funding your trust or drafting your will, but we are talking about making sure that you have a cohesive plan. Now, we're going to be using this for multiple things. It's going to be up as a YouTube video, but we're also going to put it into some materials to show people about how they need to make sure their assets are lined up with their actual written legal document plan. Whether it's a will or a trust, it's got to line up. So the first thing we want to make sure that we're talking about is this fallacy that if I have a last will and testament and it says here's everything that has to happen, that's what happens regardless of how assets are titled or how beneficiary designations are put together. That's just not the way it works. And here's the biggest mistake. If, let's just say, you're not married for the sake of this example, you have 3 kids and they're all young, and you put into your will that I want everything to go equally to my kids, and I want to put in place an age limit of 30. So they won't get these assets outright until they're 30. In fact, the kids are 8, 11, and 15. And you list your kids as the beneficiary on this bank account, and then you pass on before, let's just say that they're 18, 21, and 24, they get the money right away. But wait a minute, my will says they don't get anything until 30. Well, that's because your will only covers what goes into probate, and you've taken it out of probate. All right, the whole decision of whether you want to avoid probate or not, it really should be that simple. Is avoiding probate a big piece of what I want to make sure I'm accomplishing? Or is it, no, I don't care about probate? It shouldn't be any of this real in between, come to an exception, at least without some tax reason for it. So if you want your last will and testament to spell out, here's exactly how I want my estate to go. If this person passes on, here's where it goes, here's all these contingencies, and I want to put an age limit in place, then don't do something with your assets and accounts that avoids probate, because your will only covers what goes into probate. If it's not in probate, your will has absolutely nothing to say about the matter. So if you do decide you're going to do a last will and testament because you don't care about probate, then if you want that to be your plan, make sure your assets are lining up. Now we're going to walk through a confidential financial analysis form. This is a form that we typically use in the law firm and for the Care Assistance Center and other businesses, just to help our clients have a way to gather the information on the different assets they have and how they are titled, so that we can walk through here's the best way to make sure that your plans are lining up. So I'm going to go ahead and move over to that confidential financial analysis form. And the first category of assets we're going to talk about are your cash and savings. All right. For cash and savings, really, this is just anything dealing with the bank: checking, savings, money market, CDs, things like that, where they have a titled ownership to it. And this ownership is what's going to end up keeping your assets lined up. If it's in your name and you pass on without having some kind of beneficiary designation, then your will controls it.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
So if you have these accounts, they're in your name, well, who is the pay on death beneficiary? Estate. That's the term. You put estate as the pay on death beneficiary. Make sure that is on there. Occasionally people just leave it blank, but oh yeah, then it'll just go to my estate. That's not 100% guaranteed. That's usually what happens. But there have been instances where we've worked with clients and their accounts, and we recommended name the trust as the beneficiary, and they just didn't do it and said, well, that's what the will's for. Well, it actually said that it goes to your next of kin, not according to your estate in the contract for the account they set up. So it didn't go where they wanted it to go. So if you want your will to control it, it needs to go to your estate. So that's what you put on the checking, savings, money markets as the pay on death beneficiary. Don't just leave it blank. And don't put anybody's names in there because then it's not going to follow the restrictions and other things that you put into your will. All right, next category of assets, real estate. All right, this usually is pretty simple. Your real estate, it's titled in your name, or if you have a joint owner, okay. And usually, if it's with a joint owner, it's joint with the right of survivorship. But here's the thing, if it's joint with the right of survivorship, that overrides whatever is in your will. So let's just say it's you and your sister own a house together, or you inherited it together. It shouldn't be joint with the right of survivorship if you want your half to go to your kids. It should be as tenants in common. That means your 50% is controlled by whatever you have put into your will. So that's something to take into consideration. Now, if you have real estate in multiple states, then this could become an issue with multiple probate proceedings. But again, look, if you've decided probate is not a big deal, and you're using a will and this is how you're going to have your plan, well, then, okay, that's what's going to happen. In the weighing the decision, should I try to avoid probate for everything and go towards a revocable trust or not? Let's just go ahead and do a will. Keep this in mind at that decision point, which is if you have real estate out of the state that you're in, there's very likely going to be some kind of ancillary probate proceeding in that particular county where you have that real estate. So for like clients in North Carolina, this is how it would work. Yeah, they live in Raleigh, North Carolina, and they have a primary residence there. They have a condo down in Myrtle Beach, and they have a vacation house up in Williamsburg, Virginia. So South Carolina and Virginia, they've got real estate, but they have a house and they live in Raleigh, North Carolina. All right, there's going to be a probate proceeding in that county in Virginia and that county in South Carolina, in addition to the main probate. Again, if you've decided it doesn't matter, well, then make sure that your real estate is owned just in your name so that it's controlled by the will. All right, let's move on to the next category of assets, and that's securities. All right, let me be clear about securities. When we're talking in this context, it's your stocks, bonds, mutual funds, brokerage accounts, stuff like that, but it's your after tax dollars. Look, if you've got an IRA or a 401k, oh, yeah, it's invested in stock. That's not what we're talking about with this particular category. Those have very specific tax rules, which we will address later because there's a separate section just for that. It's your after tax dollars where you're paying taxes each year on your dividends and interest and all of your capital gains and all that other stuff. You're paying that every year. All right, this is what the securities are. This is also based on title, and usually these brokerage accounts or mutual funds, they may have a pay on death beneficiary. In that case, it's the same thing as the bank account. You want your estate to inherit that so that it goes through that probate process so it can be governed by the will. So if that's what you want, okay, the will cover it, but it has to go into your estate. And really, there's not going to be any kind of tax difference here if it goes into your estate as opposed to if it goes to those named individuals. But by having this go into your estate and your will covering it, all the age limits and contingencies and all that other stuff that's written in there, all those restrictions, those will take hold and govern how those stocks, bonds, and mutual funds are distributed out to the beneficiaries. All right. The next category of asset, really, this is the miscellaneous. Now, when I'm sitting down with my clients and running through the different types of assets and what they do and how they should be treated, this is where I tell them when you're filling out the form, if you don't know where it goes, just stick it here and we'll figure out if it needs to be put somewhere else. But this is things like promissory notes paid to you. Oh, I sold my house to my cousin and they're paying me off over the next 20 years.
right? You're receiving that stream of income. Oh, it's something like vehicles, right? You list them here. Oh, I've got this really expensive piece of artwork and it has titled ownership to it. It actually has ownership certificates, not certificate of authenticity, those old Franklin Mint things. That's just certifying it's genuine. A certificate of ownership says in writing, here's who the owner is. All right, that's a titled ownership to it. That needs to be compliant with whatever your estate plan is. So if it has a certificate of ownership, if this were a trust case, I'd say, well, you want to have it transferred to the trust. In this case, no, you want it listing you. And if somehow or another, I don't usually see this, but it could be there. If there is a transfer on death beneficiary, you also want that to be your estate. So this way it ends up staying in probate. What about those promissory notes and those streams of payments? Well, okay, you leave that blank because it means it's an asset of your estate, which the court can deal with and either accelerate the payments, direct them to a beneficiary. So it all gets worked out in accordance with your will, with your last will and testament. All right, retirement plans. Okay, here's where we do have some potential tax consequences to it. And so not only are you deciding, do I need to avoid probate or does this need to go via my will? If you want everything to go via your will, then that means that this has to pay on death into your estate. But here's the thing, there are tax consequences. You need to talk to your tax professional about what those consequences would actually be. But what I know is one thing you're not going to be able to do is have the beneficiary just inherit it and set up an inherited IRA, and they can take those payments out over the next 10 years. I think the most you're going to get is 5 years, and it's an even schedule. But again, I could be mistaken on that. Talk with your tax professional. But one thing you're not getting the 10 years for the beneficiary. Now, what if all you have is $30,000 in an IRA and you've got two young kids as beneficiaries? Whatever those tax consequences are going to be, it's better to have those tax consequences by and large, but have the money end up being controlled by the trustee via the last will and testament. So that testamentary trust that's set up to take care of the kids, and it falls into that control of the trustee that you've named, regardless of what those tax consequences are. All right. If you have several hundreds of thousands of dollars that would go to an underage beneficiary, there is also the option of doing an IRA trust, but usually, I'm just telling you what I've seen as a, in my attorney practice, I have not seen anybody do an IRA trust because they want the 10 years, but they want the trustee to control everything. And yet they're doing a last will and testament as opposed to a revocable living trust. Usually it's a revocable trust and then the IRA trust to handle the tax consequences of it. But again, up to you. It's always out there as an option, but I'm just telling you what I see. But the important thing is to make sure that if you want your will to control it, then your beneficiary on that IRA, 401k, or whatever other retirement account it is, it should also be a state, but you want to look at the tax consequence. Occasionally, I have clients, they've got just one main IRA. They'll have that kind of go outside the will as part of their plan, just to keep it simple so that it's in everything else is in probate and therefore covered by the will. But that's one piece they're looking at separately. All right. So the last category of assets we have is life insurance. Right. And this is usually a selling point with life insurance. Oh, it avoids probate. Just name the beneficiary. It avoids probate. It avoids probate. It avoids Well, if it avoids probate, like I said, it also avoids that last will and testament. And here's all the contingencies and here's the age limits. And look, you got to make this line up with your will if you want it to do that. So, what's the beneficiary? Estate, just like with the bank accounts. if you want the life insurance to be controlled by the will, then it needs to go into probate. And therefore, your beneficiary for that life insurance should be a state. Another piece of this, and I've got a recent video that I put up about this, there was nothing that we initially could see that was actually going into the estate that would end up being able to pay for the funeral and other expenses because the client had everything else going directly pay on death to charities. We don't know. And we weren't going to know until we actually got those probate papers and could have the financial institution tell us what's in the estate and what went via pay on death beneficiary. So, okay. So, if you want everything to be governed by your last will and testament, then that means probate. All right. Make sure it goes into probate. You can't do a mix and match without things getting terribly complicated. You just have to realize that if you use any of these, what we call duct tape solutions, joint tenancy with or joint with a right of survivorship or a pay on death or a transfer on death beneficiary. Yeah, we're going to avoid probate using these little techniques for each account. Well, then your will doesn't cover it. It doesn't cover the contingencies, and it certainly doesn't cover the age restrictions and other limitations on younger beneficiaries because it bypasses probate. That's the big key takeaway from this video is if you want your will to control it, it has to go into probate. All right. So I hope you found that information useful. We also have, we'll link it in the description. We have a trust course online that's going to get this video as part of it. If you want to understand more about these different types of assets and how they have to work in conjunction with the plan, that course is going to be very valuable. But just realize it's coming from the perspective of yes, I want to avoid probate and I have a revocable trust. Here's how it works in conjunction with the trust. So that might be a valuable resource for you. We're probably going to be working on some additional courses and things like that. And we've got a couple of neat things coming down the road where we can potentially help people, not as an attorney, but help them get their estate planning documents put together across all 50 states. All right, so I hope you enjoyed that video. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.